terms, jump in if you have questions. Feel free to ask as we go through. I think you can unmute yourself on the WebEx if you have questions that way. So go ahead, because that's how we talk about real practical things that are actually happening. But I'm going to walk you through some of the key things that you should really pay attention to when you're entering into the contract. As Derek said, some of these contracts get signed without a lot of review or analysis, and then later when you have a problem, you look back and you go, oh, that's really what it says, right? And at that point, you're stuck. So the idea is, let's maybe look at a few of these ideas or these topics and try and head it off next time you get a contract that crosses your desk. Obviously from a construction standpoint, you're building a project, your key issues are, can I get it done on time and can I get it done on budget, right? That's what the owner's going to grade you on, or the general contractor's going to grade you on. But there's a lot of different types of provisions in schedule language that you should look for. So the first is, when do you get an extension? What kinds of delays would give rise to you being able to submit a change order and ask for additional time? Usually it's fairly limited. I mean, a lot of what I'm talking about is kind of the AIA standard documents. Contractors often have their own standard subcontracts, so that may or may not be different or may or may not track the AIA. But you can typically get an extension if there's an owner-caused delay, right? The owner has an architect who's causing some delay. They hired kitchen consultants or kitchen designers or somebody else as their own separate contractors. Maybe those people interfere with you. The owner fails to make a decision about some material purchases. You could also get an extension if there's unexpected or hidden conditions. You find something in the subsurface soils that wasn't expected. But you have to make sure that it wasn't something that was in a geotechnical report that you had access to at the beginning of the project, right? So it's got to be unexpected, meaning could I have known about this when we started the work, right? Unusual weather conditions, that's always a tough one. They've got to be unusual and adverse and have an impact on your schedule. And you're going to have to be able to show that they actually had an impact, meaning how many weather days did you build in, right? Because we all know that in Wisconsin, you're going to have some weather impact. So to be able to show that it was unusual, you've got to say, well, normally we have 6 days during the winter where we're impacted. So I built those 6 days into the schedule, but this year, because of snow or cold or whatever, we had 10 days. So you've got to be able to show what you normally would have expected, that you included that normal in your schedule, and that you actually incurred more. So weather is, I think, tricky. Delay in release of plan or bid packages. These are often projects where you're getting different bid packages, right? It's coming out in phases. If those are delayed and you're the general contractor, yeah, I think you can ask for an extension of your time. Force majeure events, that's basically things like acts of God, right? Tornadoes, fires, wars, things that nobody can control or could have anticipated. So once you figure out when you can get an extension, then you need to look at the language and find out how much time you're entitled to. Ideally, you want to be compensated on a day-for-day delay. So you have 1 day of delay, you get an extra day added to your schedule. I've seen owner contracts that say you only can get additional time after you've lost 3 days, or after you've lost 3 full days. Also, if you lose 15 half days because you're shoveling snow, what does that mean, right? So you really don't want language that says you have to have certain, losses first before your right to get an extension kicks in. Then, the next question is, can you get paid for that delay? Well, it kind of depends. Often the contract says no, you only get additional time for things like weather. But I think the idea being you weren't there working, so you didn't incur those costs. You only lost time, and so you only get time. But you're gonna wanna make sure that if it's something you think causes you additional loss, that you can actually be compensated for it in the contract. And then your subcontracts need to be consistent, right? So if you're the general contractor and you agree that you only get to ask for additional time after you've incurred 3 days, you're going to want to make sure that your subcontracts say the same thing. Typically, your subcontracts will incorporate by reference, the contract with the owner, but this, I would really love to see you actually incorporate something like that, right? Because you don't want to have to argue about whether the sub had actual notice of that. Did you give them a copy of the contract with the owner? So try to make sure that your contract language is consistent, and that's the theme throughout this, right? I mean, if you're the general and you're on, you've got an owner contract and a subcontractor. You're a subcontractor and you've got second or third tiers and a contract with the general. You want to make sure that all of those things work together. Pay attention to deadlines for claims, because often there's going to be some language in the contract that says if there's an adverse event, or if there's a change or something that happens where you think it's causing you additional cost or additional time, you need to submit your change order request within X number of days, or you need to submit your claim within X number of days. And again, if you've got a subcontract that's on that same project, then you want to make sure the subcontractor maybe has 2 days less, right? So that you can get those claims in before you have to have your claims in. If you have a change order that you think you're entitled to because of a certain situation, and you're not sure if it's going to cause you additional time, what do? Most people don't like to ask for additional time. In my experience, at least, people would rather ask for money than time. But if you don't ask for time on that change order, you're likely not to be able to submit a second change order 3 months from now that says, well, way back then when I submitted that, I didn't really know the impact and I didn't ask for it. The owner may come back and say, well, that's what you asked for, and that's all I'm going to give you. And you missed the deadline. And so why would I, let you have second chance? So, even if you aren't sure what the impact is in terms of time, or you're not sure you want to ask for it, your better course of action would be to make a note, right? This change has caused, will cause additional time to be incurred. At this point, we don't know exactly how much time, right? Give them a heads up that you think it's going to take extra time, and you're potentially going to come back and ask for that later. If you're behind schedule, what happens? Usually the contract says the owner has certain remedies. They can typically require the contractor to work overtime at their cost, or expedite deliveries, or add workforce, or take some action at the contractor's expense to catch back up to the schedule. The owner can also take over all or part of the work on the AAA documents. They do have to give you some notice, but that is one of their remedies. There's a possibility that they could terminate depending on how severe the situation is. And so you're going to want to know when they have those rights, right? What triggers the owner's remedies? Sometimes the owner contracts will say, if you fall behind schedule, owner can do X, Y, and Z. Well, honestly, if you look at the schedule as a general contractor, probably at any given time, something might be behind because maybe you shifted this here, or maybe you're 2 days behind, but it's not a milestone date, right? It's just like your progress dates. So I wouldn't want to agree to language like that. I would want to make sure that that language said, if you fail to meet a milestone date, right? Some date that is actually a significant date in terms of the progress of the project, not just, we've got 2 weeks to do the concrete and, oh, it looks like we're 2 days behind. So Schedule also comes into play with different types of damages, right? Because if there are delays, everybody wants to know what kind of damages can I get. Owners will either typically talk about liquidated damages or consequential damages in contracts. A liquidated damage is a fixed amount for each day that the project is delayed. So the language would say, for each day that you miss substantial completion, you'll pay the owner $1,000 in damages. Consequential damages are open-ended. They're more like lost profits. So the owner could come in and say, because I was delayed in opening my hotel, I missed out on this convention that was booked, and here's the revenue loss, right? And it's sort of an unknown when you enter into the contract, but it's pretty open-ended. The standard AIA documents and the consensus documents contain mutual waivers of consequential damages. In my view, you never want to agree to strike that, right? You always want to keep that mutual waiver because an unknown amount of damages could bankrupt your company, right? I mean, nobody can withstand an unknown amount of damages. Liquidated damages, most contractors don't like those either. So which is better? It depends. I mean, I think some sureties have said, hey, look, if it's a liquidated amount, we at least know how much it is, right? Contractors may say the same thing. I know that if I'm going to incur $10,000 a day, it's better for me to put my staff out there and work overtime that whole week before we are late so that I don't have to incur that $10,000. If it's $1,000 a day, maybe you take a different analysis. If it's consequential and you say, I wonder what my damages are going to be, that's a little scary. So, it's really a business judgment call. In my view, you try not to have either one, right? But if you're going to be forced to have one or the other, maybe you pick the more certain one that at least allows you to have some control over what the total amount of damages would be. Whatever the general contractor negotiates with the owner is likely to get passed along to the subs, right? And the subs are pretty much in no position to dispute that, right? The deal has been negotiated already, so the subs just end up taking whatever those terms are. As a subcontractor, I think the key is, make sure that those damages are only allocated to you to the extent that the delay was your fault, right? And so there's often some, disagreement or some wiggle room in terms of how much fault a particular party was at and how much contributing fault somebody else might have had. So another, shifting gears a little bit, another topic is change orders. Again, when can you get a change order? When are you entitled to that additional time or money? Typically in the contracts, it'll say that if there's change conditions, like site conditions or hazardous materials, something that you find on site that you didn't expect. If there are changes in the plans or specs, so materials changed from when you first bid the project. Changes in scope, which happens often, especially if you're bidding the project before construction documents are complete, right? So as a general contractor, we often see you have to give the owner a price, right? Or you're trying to give the owner a budget, or you're trying to give the owner a GMP. Sometimes those are based on 50, 60, 70, 80% complete drawings. So if there are changes then in scope or changes in materials or whatever the changes might be between that 80% and 100%, that would potentially give you a rise for a change order if those costs are significant. And then delays, and we talked about that a little bit already, but you could typically get change orders for those items. Almost every contract I've ever seen says change orders have to be in writing, signed by both parties before you perform the work. Which we all know. You don't do that? Yeah. No, it doesn't. And I understand why. But that doesn't mean you're not at risk when you go ahead and do the work first, right? Most of the time, it doesn't become an issue. But if there's a dispute on a project, You know, one way for there to be, for the party sort of to dig in is for, you know, the general contractor to give the owner a giant change order at the end of the project and say, okay, here's all the changes we made. It's going to cost you, you know, an extra $2 million, right? Nobody likes that. And if there's anything happening on that project already, that's going to just be another thing to add to the pile that you have to work through and rehash. And if you haven't done this, you haven't gotten that signed change order, they're going to go back to that contract language and say, but look, it clearly says you can't do the work until we sign off. Sometimes the language is also, you know, even worse, right? And it says, a claim for a change order is waived if it's not in writing prior to the work being signed. Or no, you know, no pattern or practice is being created by paying for unsigned work or by, you know, allowing work to be performed before a change order is signed. That language, in my view, is even worse than the original, you know, don't proceed with without having a signed change order, because it's trying to do two things, I think. It's saying you waived the claim, right? So not only did you not do what the contract says, but you actually waived it, which legally is a harder argument to say, oh, no, I didn't, you know, I didn't mean to, right? Well, it's pretty clear in the contract that it's saying you waived it. There's also case law in Wisconsin from a while back where they didn't sign change orders, but they went through and the owner, you know, paid for them and they created this pattern in practice, and the court said, well, by doing that, you both agreed essentially to modify the contract language that says you have to have a change order in place before you do the work. This, you know, additional language where it says we're not creating a pattern or practice is intended, in my opinion at least, to eliminate that argument in that case, right? So what do you do? I mean, I realize it's not very practical to say, stop everything you're doing and get a change order signed. And you're taking a risk by not doing that. But I think you can minimize your risk a bit by making sure the owner or the general contractor knows it was a change, right? Email them confirmation. You told me to change, you know, this outlet from here to here. This may result in additional cost or additional time or whatever the case may be. You know, we'll follow up when we have that information, right? Just at least tell them that what they asked you to do is a change. If you have some cost or estimates or whatever, include that. You could also, if it's, you know, at a meeting where this comes up, include it in a meeting minutes. If you've got a project log or a change order log, maybe you put it on there even though you don't have a signed change order and you just say pending, right? The whole idea is give them notice as soon as possible, ideally before you actually do the work, even if you're not getting a change order signed. Again, you know, is that a foolproof method? No. Because they can certainly look back to the contract and point to that language. But I think, I always feel better being able to make the argument that, well, you moved, right? It's not like we hid it. We told you it was a change. We told you approximately how much it's going to cost. You know, we did the best we could at the time, essentially, right? You didn't want us to stop and wait until we had the pricing in. So I think that helps from a fairness standpoint if you have to argue that point. You always want to know, make sure you know what the deadlines in the contract are. You know, you'll have deadlines for shop drawings and submittals. Typically, you'll have deadlines for, you know, submitting draw requests. You may have deadlines for submitting change order requests. There are also often things that the contract requires you to submit with the change order. So make sure you know what those things are, right? If you're submitting a change order. There are deadlines for claims. So in the A201, for example, and it should be 15.1.3 in the new version, but it says, you know, if you're a general contractor and you've got a claim, it has to be submitted within 21 days after the occurrence of the event giving rise to the claim, where you first recognize the condition giving rise to the claim, unless a different deadline is specified. For some reason, in the 2017 AIA, the A201, the changed conditions language that used to say you have 21 days to notify the owner of you know, the claim under the change conditions paragraph. They changed that to 14. I don't know why. I always change back because it used to, and it was always 21, and 21 is consistent with this, right? So by changing it to 14, I think, you know, either you've got to be aware of that, so if that's your situation, your deadline is shorter, or you may want to just go, change back if you have some negotiation to do with this contract. If you're a subcontractor, there's language, and you're using the standard, you know, AAA form. It's in the A401. There's a section that says your claims have to be submitted by the time that the contract says, but not later than 2 working days for the general claims to be submitted. And then, you know, there's always statute of limitations, which is basically a state-by-state limit on when you can bring a claim. So if you're working in Wisconsin, for example, and you've got a breach of contract claim, you've got 6 years from the date of the breach to bring that claim. Every state is different. So you need to know where your project is, and then you need to know what your claim is, or what your, you know, what the statute of limitations is in that state. There's also language which I think sometimes gets overlooked in the AAA documents. And it's in like final payment or some paragraph like that, where it says basically if you submit your final pay request, you're waiving all claims, except those claims that have been identified in writing, and there may be one other exception. The exceptions are pretty limited. So if it's a claim that you haven't made, or you haven't made clear that's still, you know, in dispute, and you submit that final draw request to the owner, be prepared for them to come back and say, well, by submitting that, you know, you waived all of your claims. So, you know, if there's change orders open or something that hasn't been resolved, I would suggest with that final pay request, you send a note, right? It's not something in writing that says, just a reminder that we've got, you know, these 4 issues that haven't been resolved, and we're not waiving them. So then we get to indemnification, which is everybody's favorite topic, right? You get these long paragraphs, and they might have like 10 different parts. And what does it really mean? Well, indemnification simply is to require one party to reimburse another party for a claim by a third party. So you're the contractor on the job site, and somebody walking by on the sidewalk is injured by something you've done, and that person sues the owner. Then the owner is going to look to you and say, hey, that person was injured, they sued me, but it was really your fault because you did or didn't do something that you should have been doing. And I expect you to reimburse me for those costs that that person is seeking from me. It's generally, you know, seen as a risk allocation strategy, right? So if you're the contractor or a subcontractor, the idea behind indemnification is to shift to you the risk that you can control. And that really should be the idea. I mean, it should be based on your work, right? Or your subcontractors, or your failure to do something, not shifting to you something that the owner should have done but didn't do, and now is looking to you to you know, pay for those costs. You'll find indemnification provisions in several different places, typically in the contracts. Usually there's a general one. You know, if you fail to perform, or you, you know, for your acts or omissions, or there's some negligence, right? You'll see some general language about how you have to indemnify the owner and perhaps different parties for that. There's also often one from liens, right? So if a construction lien is filed, typically as a general contractor, as a subcontractor, if it was somebody under you, they're going to look to you to indemnify for those costs that are incurred to defend against that lien. Violations of laws or fines, you know, if you get an OSHA violation and there's a fine or penalty that goes with that, that would be, and then, you know, OSHA cites, let's say the general because of something you did. The general may come back and say, look, the only reason we got this violation was because of your violation. general workplace violation maybe that the contractor got, they would probably look to the sub then who caused it to say, hey, this was your fault, you need to indemnify us for that. And then there's typically one from the owner for hazardous materials. So when you're looking at indemnification clauses, what do you look at? There are a number of key things. You want to find out, when is that obligation triggered? Is it a loss, some sort of broad language? Is it discovery of hazardous materials? Is it because of a construction lien that was filed? Something that generally it should be something relating to the work, right? And that would often be like capital W work, which means your scope under your contract in most contracts. Then you want to look at, who are you indemnifying? Because sometimes there's a really long list, right? It's the owner in every case. Does the owner have a property manager or an affiliate, or are they asking you to indemnify the architect? Are they asking you to indemnify their other contractors? How long is that list? And can you make it any shorter? Because the fewer people you have agreed to indemnify, the better, generally. And then who are you responsible for? If you fail to do something, is it just your failure? Usually it's going to be your failure, your employee's failure, your subcontractor's failure, and anyone for whom you might be directly or indirectly liable, which is pretty standard language, but opens the box a bit, right? Who are those people that you might be directly or indirectly liable for? If it goes beyond that, then I would ask some questions. Then you want to look at what the extent of your obligations is. So, in my opinion, again, you're trying to make sure that it's just your work or your acts or omissions, something that you have done. You don't want to take on somebody else's liability. So, I often see in contracts when from the owner especially, if they're talking about a construction lien, they will say, you're responsible for indemnifying them for liens filed against the project. Well, wait a minute. That could be by the architect, who I don't have a contract with. That could be by the owner's separate contractors because they hired, a kitchen designer or a kitchen consultant or somebody who's installing their, theming or something else. So you really wanted to say, liens relating to the work, capital W, right? Because that then, again, narrows it to the scope of your contract rather than the project as a whole. You also want to look at whether it's, again, limited to your responsibility. And often it will say, I will indemnify you to the extent the claim arises from my negligence or the negligence of my subcontractors or suppliers or employees. Sometimes I see language where it says, I'll indemnify you for my negligence or for a breach of contract or for damages that arise from the work. And then there's kind of a carve out that says, except when those damages are the result of the owner's sole negligence. Again, I don't like that because if the owner is 97% negligent, then it's not their sole negligence, so then I'm responsible for indemnifying them for their 97%. That doesn't seem fair, right? So you'd want to cross off sole in that case because you want, again, to have it be proportional, right? To the extent that the owner did anything wrong, you shouldn't have to indemnify them for their share, even if it's 40%. And, even though I'm talking about, a lot of these, I'm talking about in the context of owner contracts because those are the AA documents often. You'll see the same thing in subcontracts, right? You want to make sure that the language in the subcontract doesn't require you to indemnify the general, for example, unless the general is solely negligent. That would be the same thing. You'd end up indemnifying the general for some of its own negligence, unless it was 100%. Depending again on where your project is, there are state laws that dictate how much liability can be shifted to another party. So in a lot of states, they will say it's invalid, it's invalid or it's void to shift your negligence to another party. So if you're trying to do that, you should make sure you know whether that's possible in the state that you're working in. And if someone else is trying to do that, you know, you're generally going to try and avoid that anyway, right? Insurance is often also another complicated issue. And there's a lot of detail on some of these insurance provisions. And honestly, my best advice is typically to say, make sure your insurance agent reviews those, because they will know what your coverage is and how much coverage you have and whether there are exclusions to coverage. Sometimes the language will say, make sure you have an endorsement for contractual liability, right? That means if there's things you've agreed to, like standard indemnity terms, you know, does your insurance cover those? That contractual liability endorsement typically would make sure that you were covered for those things, as long as they were sort of standard things that you typically are agreeing to take on. The additional insured provision, so there's always something that says you need to name, you know, the owner and the architect or the general contractor, whoever it is, as an additional insured under your policy, which basically means they can make their own claim on your policy. Often they have specific forms that, you know, they'll list, like they want you to use a particular additional insured form, because the different forms, as I understand it, have different language that, you know, provides for different types of coverage, right? So again, take that back to your agent and say, hey, you know, can I provide this form? Is this something that I have? Is it going to cost me more money? Mold, you know, that was kind of a big thing for a while. I don't see it as much anymore, but you know, mold coverage would be typically an additional endorsement. They're not going to have coverage for mold in your standard commercial general liability policy. Usually you've got to provide whoever you're contracting with proof of insurance, often before you set foot on the project site, right? So you'll need to send them a certificate of insurance that shows you have the coverages that are required by that contract, that you can name them as additional insured, that sort of thing. There's often waiver of subrogation language in the contract. And again, that's something you're going to want to make sure you run by your insurer, because subrogation is their ability to step into your shoes and make a claim against a third party, right? And if you waive that, your insurance company may not be happy about that, but they are pretty used to seeing that type of language. So again, I would just do a double check. And maybe you don't have to check every contract, but you know, do an insurance review once a year and make sure that the language that you're typically seeing is going to mean you've got coverage. And then again, make sure your contracts on the same project are consistent. So if you have certain requirements with the person you're contracting with, you better make sure that those flow through to everybody below you, right? Everybody that you are dealing with, so that they can provide the same levels of coverage. Because if you're a subcontractor, the general's going to look to you for that $2 million of coverage, because that's where their contract is. And if it was even if it was caused by one of your subs, if they only have $1 million, you're going to be on the hook, right? You want to make sure that these numbers and these coverages flow through, so that you don't end up stuck in the middle. Payment, you know, everybody typically looks at, you know, what are my dates, right? When am I going to get paid? Am I going to get paid within a certain number of days after the general contractor receives payment? Am I going to get paid, you know, by the 25th of the month if I submit it on the 1st? So make sure you know what those deadlines are. Pay when paid is allowed in Wisconsin. So something like I'll get paid within X number of days after the general gets paid is okay. But you can't have pay if paid, right? So if the general never gets paid, you're still entitled to your money. Generally, you're going to see retainage on your contracts somewhere. I usually see somewhere between 5 and 10%. The owner, you know, won't release that retainage in most cases until final payment and acceptance of the project. If it's a long project and you're the general contractor, maybe you want to put some language in that says I can ask for retainage to be released, you know, at certain periods of time, right? Maybe my earthwork guy is done in month 2, but the project's not done till month 18. Your earthwork guys, your sub is probably going to want to see if you can release retainage to him before, you know, month 18 or 19 or 20. So sometimes I'll add language that allows you to ask for it. Usually the owner isn't willing to commit to releasing it, but they will often let you, put some language in that says if the owner has accepted the work, or if it's, an early phase of work, the owner will be cooperative or work in good faith to release retainage, something like that. Subcontracts often will say, we won't release retainage to you until you have all of your warranty information in, you have your O&M manuals in, anything that's required documentation-wise of you on the project might be a condition of you receiving retainage. So make sure you know that if you're a sub going into it. And then you typically, as a subcontractor, are going to have the same obligations to pay your subs and suppliers, right? Because we talked a little bit about how it can be paid when paid, but not paid if paid. So regardless of your situation with the general, if you've contracted with somebody, you've got that same obligation to make payments to them. If you don't, then sometimes we see liens against the project. But again, your best case scenario is to make sure that that type of payment language flows through. Generally, remedies, if you don't get paid, you usually stop work, right? You might have to give some notice. So the AAA document says if you're not paid within 7 days after the date it's due, you can give an additional 7 days notice and then stop work. Subcontracts will have something similar, typically. If you're a subcontractor and you're not paying your subs, often the general, that will raise a red flag for them, right? They want to make sure that everybody's getting paid so that there aren't liens on the project. So general contractors, subcontracts will often say, the general has the ability to enter into joint payment agreements with the subcontractor or a direct payment to the subcontractor. And the contract between the general contractors and the owners, the AAA version, has similar language so that the owner could actually pay subs directly also. If you're the general and that doesn't appeal to you, sometimes I'll add language that says if the general contractor is in default with subcontract, right, so that the owner can't just pay no matter what. You might want to limit the circumstances when they can pay, because a lot of general contractors want to control the payment, right? You want to make sure that you're paying something that's due and that's not in dispute. And so if the owner simply makes the payment without consulting you, sometimes that causes problems. If somebody's not being paid in Wisconsin, they can file a construction lien. There are deadlines in the statute. Generally, liens have to be filed no later than 6 months after you first performed work on the project, after you last performed work on the project, and 30 days before that, you've got to serve a notice of intent on commercial projects, at least. There's always language that I see in owner contracts that says the owner doesn't have to pay you if there's a lien. Right, and to some extent, the owner gets to withhold funds if a lien or claim is filed. There's disbursement agreements that come from the title company, typically have similar language. My advice on that is try to make sure that that language says they can withhold 150% of the amount of the lien, rather than that they can withhold payment. Because payment could mean your entire $10 million draw, because $20,000 lien is filed. So try and limit the ability to withhold to something, like a percentage of the lien amount. The statute requires the general contractor to defend the owner in any lien action that's filed that's not a result of the owner's failure to pay in Wisconsin, under Wisconsin law. Generally, that's going to be something in the contract, and it's also going to be something in the subcontract. And then, typically what you will see is that if a lien is filed, the general contractor, for example, will post a bond, and then there's a process in the statute that basically you have to file that with, with the clerk of courts, and the bond is the security rather than the property. So there are ways to deal with liens that are filed that owners can typically feel okay about and not pushing too hard to resolve the matter, but generally you're going to have to post a bond so that the owner's property is not at risk of foreclosure Also, in terms of payment, you know, often you're going to say your contract is either going to be a unit price, if you're a subcontractor maybe, or if it's you're a general contractor, it's maybe going to be a fixed price or a cost plus. Those typically don't, unless it's a cost plus, those typically aren't going to allow you to recover fluctuation in the price. So if you're a subcontractor and you are providing asphalt and your contract is in, I don't know, August, and you're going to be delivering the asphalt in April, and you know that there's always an increase in the cost of the material in February, you know, maybe you want to build in an escalator or some language that says that, you know, here's my price, but I have the right when the price increases to increase this unit price by up to 5%, right? You probably want to put some cap on it because the general's not likely to give you just an unlimited right to increase that cost. But if you anticipate material costs going up, because they always do on a particular time, or you know your labor rates always increase at a particular point, unless you have some escalation clause, or unless it's a cost, you know, plus fee type contract, you're going to be bound to the original price that you submitted. So think about that if it's something that applies to your situation. Deficiencies in the work, what happens? You know, there's always some language in contracts or subcontracts that talk about failure to perform. Typically, you know, the general contractor or the architect and owner, somebody's going to have the ability under the contract language to reject the work. There's also going to be seen, you're going to be seen to be in default or be deficient if you fail to comply with the project schedule. If you don't complete the punch list work, you know, within a reasonable time. Those are going to all be seen as, you know, ways to be in default with contracts. So what does your contract say? If you're in default, does it say that you have to get, you know, written notice and a chance to cure? The AIA standard termination language doesn't for a cause. So I always add that in, right? You might want to look back at that and say, if I'm still in default after I receive notice from you and, you know, 10 days to cure, then you can terminate me. Subcontract language, you know, is going to be pretty much the same, right? So look to see whether they have to give you notice and whether you get any chance to cure the deficiency. If you're giving notice, make sure you follow the manner of delivering notices, because typically contracts will say how you have to provide notice to somebody else, to the other party. Sometimes it will say who you have to give the notice to, but often it says notice has to be provided by, you know, certified mail or you know, overnight courier or some specific method. So make sure that you follow that method. And then if you're getting the notice, somebody sends you a deficiency notice, make sure you respond to it. You know, don't just throw it in your drawer and say, I don't believe that I'm in default. You know, send back a letter that it doesn't have to be a long letter, but at least say, you know, I disagree with the assertions you made in your letter, right? I mean, you don't want to just sit on it and wait to see what happens. Often in subcontracts, there's going to be some duty to inspect work that you're putting your work on top of, right? So if you're providing flooring, you know, you maybe need to make sure that the concrete underneath is suitable for you to install your flooring. Maybe it's a moisture issue or, you know, whatever it might be. How far does that go? Kind of depends on the contract, the subcontract language. Certainly would apply to anything you could see, right? If it was an obvious defect, then I think you're clearly going to have that duty of saying, hey, this, you know, concrete wasn't cured properly or wasn't, you know, poured properly or whatever. Do you have to do tests and other things? Kind of depends. You know, make sure you know what the language is, because typically if you have that duty and you fail to comply with it, and there's a problem, and you know your flooring has to be torn up and then somebody else's work has to be patched, that's all going to come back to you. Termination rights, you're also going to see in pretty much every contract. You know, what do they say? usually there's a right to terminate for cause. Breach of contract, safety violations, repeated safety violations, maybe, you know, some sort of act of default. There's often also a right to terminate for convenience, which means anybody, you know, could terminate you just because they want to go with somebody else, or they have decided, you know, that they're not going to build the project for whatever reason. Normally, a termination for convenience is going to result in you being paid for work already performed. The standard AIA language even gives you some right to, you know, overhead and profit not earned, essentially, although that usually goes away if you're negotiating with an owner. And often I'll want to add, you know, other costs of termination, right? So if I'm a sub and I order materials or equipment and I'm going to have a restocking fee, or I'm going to have a, you know, cancellation fee, make sure that you think your language covers those things, because termination for convenience really is supposed to make you whole to the point that you're at, right? You're supposed to end up at an even standpoint. Termination for breach or cause typically means you get paid for what you've done, but to the extent you haven't done something, or to the extent that there was a deficiency and someone has to come in and finish that work or fix that work, then those costs to finish or fix the work will be charged against your contract. There's also usually a right to assume contracts. So the owner's contract says, we terminate you. We want to be able to have all of your subcontracts assigned to us. I usually say, hey, wait a minute, if you terminate me for cause, sure, I'm okay with that. But if you terminate me for convenience, then why would I have to assign all of my subcontracts to you, right? I mean, you should then go out and get your own subcontracts. Again, look at what the notice requirements are. Typically, you'll want to make sure that you promptly reply to those. If the termination, as I said before, is for breach or some sort of cause, then the owner or the general can typically correct the deficiencies, deduct the costs that are due from that they paid from your balance due under contract. Subcontractors will often have the rights to terminate for the same reasons, right? So often we'll say the subcontractor has the same rights against the general that the general has against the owner under the contract between the general and the owner. And again, you can typically recover payment for work performed, provided that the termination is not your fault. Dispute resolution. So almost every contract will have some paragraph or section that tells you what happens in the event that you've got a dispute. How are you going to resolve it? The current versions of the AIA documents typically now have a box to check. Do you want to do arbitration or litigation? And unless you want to end up arbitrating one case with the owner and litigating with your subs, make sure that those flow through, right? So that all your contract provisions on dispute resolution are consistent. Because you don't want to go to court and wish that you could have brought your subcontractor in with you, but your subcontract says arbitration, and so you can't. And then you end up fighting about it twice. So which should you pick? Well, it kind of depends. There are pros and cons to both. Again, it's sort of a business judgment call. Arbitration is binding, so it's not like mediation, which is just to see if you can negotiate a resolution with, you know, a third party helping you. Arbitration is binding, so it's sort of, I mean, you have a decision maker. It's a more formal process, so it's somewhat similar to being in court, but you're in a conference room somewhere, and you know, you maybe call witnesses, and you might still have exhibits, and you put on your case, but it's less formal than being in litigation. Typically, your decision maker is someone that is selected by the agreement of the parties, and it's usually going to be somebody who has some experience in your area of dispute. Right, so it's probably someone with construction experience. It might cost you about the same to litigate and arbitrate, depends on the situation. I mean, a 2-day court trial might only be a day and a half in arbitration, right? So maybe it's a little bit less. The pros in arbitration, you do have a decision maker with experience and an interest typically in your topic. So it's not a judge or a jury who doesn't have any knowledge of construction disputes and might, doze off during testimony, right? It's somebody who's actually dealt with those issues before. You typically will obtain a resolution more quickly. Your arbitrators will come back and give you a written decision, usually within a few weeks or a month or so. Sometimes a court decision could take 5-6 months, depends on the situation. And you can typically get into arbitration more quickly, right? Because if you file a lawsuit, the court's calendar might say the first time we can get you in for your trial is a year from now. So arbitrators are going to be more flexible on that. And it's private. So any court proceeding is typically going to be public, right? You can go in and sit in the courtroom at the Dane County Courthouse and listen to what's going on, and it's a public process. Arbitration isn't. The big con, in my view, is that there are very limited rights to appeal. Basically, you cannot appeal an arbitration decision unless there's some bias that you can show on the part of the arbitrator, or like a mathematical error. But if you just get the law wrong, too bad. And arbitrators sometimes will kind of try to make everybody happy, right? So they might not apply the law as strictly as a court might. They might say, well, I think this makes sense here, and this makes sense here, and kind of take a little bit more of a middle of the road approach. Litigation, if it's small claims, under $10,000, you could file your own small claims action, keep your costs down, handle it yourself. There are definite procedural rules that need to be followed, right? So we know exactly how it's going to go and what's going to happen. And you have appeal rights. You can always file an appeal, take it to the Court of Appeals if you don't agree with the decision maker that made a mistake. But again, it's open to the public. It's going to take longer, and you can get people who make your decisions that don't have much experience or interest in the topic. Attorney's fees. The rule generally is each party pays their own attorney's fees, unless there's a statute that shifts it to the other party or a contract provision. So look to see if there's attorney's fees language in your contract or subcontract, and what does it say? Does it only say that the owner gets to recover their attorney's fees if they take action to enforce the contract? Or does it say, the prevailing party in any action to enforce the contract can recover their fees? Or does it say nothing and everybody pays their own fees, because that's the general rule? I think, nothing is okay in my view. Prevailing party is okay in my view, but if it's just one party that gets to recover, if there's, an enforcement action, typically you're going to want to push back on that. I'm almost done. Prohibited terms in Wisconsin. There are a few things in the statutes that you can't enforce in a contract for a project in Wisconsin. They can't require you to waive your lien rights or provide a lien waiver before payment. It happens, I think practically they do all the time. Often you don't see language to that effect unless it's maybe a national company, right, or a national owner who's building something in Wisconsin, and then I will occasionally see, language that says you have to submit your lien waiver with your draw request. And we'll go back and say, hey, look, the statute says you can't require us to do that. But practically, yeah, that's a different issue. If you're building a project in Wisconsin, you can't require the contract to be subject to the laws of a different state. So even if it's a different, an owner from Illinois, they can't require you to be bound by the laws of the state of Illinois. And they can't require that you go to court in Illinois or that you hold dispute resolution in Illinois. Those things have to happen in Wisconsin if the project is located in Wisconsin. And then again, we talked about payment language. You can't have pay if paid. You can have pay when paid. At some point, perhaps pay when paid sort of shifts into pay if paid, right? At some point, there's an obligation to make payment. You can't just say, if I never get paid, I never have to pay you. All right, any questions? We didn't have any so far, but I'm happy to take some, yes.
So on some of these prohibited terms, when they're in the contract, does it matter if you strike them or not then, because they're not valid?
It doesn't, it can't be enforced. I will often go back, especially on the lien waiver thing, just because I don't want there to be an expectation that there's going to be a waiver submitted, and it's always pretty easy to say, hey, here's a copy of the statute, you can't, include that term in Wisconsin. If you miss it, yeah, it's not an enforceable term, but I guess my approach is often to try and deal with that on the front end so that you don't end up, having somebody payment delayed because they're waiting for your waiver. Other questions?
You talked about escalation in contracts, and if it's silent, and now we're seeing tariffs coming into play, potentially impacting cost of construction, how do you see contractors handling that?
If it's silent,
Yes.
I think you're probably out of luck. Sometimes, there is language in there that talks about the fact that you have to comply with the laws, currently in effect. So if it's something maybe that came into effect after you signed the contract, you could look back at that provision and say, hey, I'm entitled to a change order because I priced it based on the laws currently in effect. And this was a new law and incurred, maybe incur additional costs. If there's not language like that, or if the law was always in effect once you sign the contract, and once you write that in, I guess I would be concerned that you can't just add on these additional costs. So yeah, that's a good point. I mean, you're right. Some of those materials, right, that are coming from different countries are now being taxed differently. Other questions?
You said when we final bill, we're waiving our rights to any outstanding change orders, is that correct? When you say final bill, are you saying a final retention billing?
Under the AIA, the A201, so depending on what contract you're bound by, this may or may not apply. The A201 has language that says when you submit your final draw request, your final payment application. So I think it's however you define that, right? I mean, arguably, it's the last one. That's when I think it would probably kick in. But you want to go back and look. If you're not subject to the 201, then maybe that doesn't apply to you. But if you are, make sure you keep that in mind if there's a project that you've got some ongoing or open disputes on. Anybody else? Okay. Thank you.
Thank you.
Yeah.
And I'll just give a quick plug for our next one. It will be November 19th. At the same time, that will be employee performance, discipline, potentially termination. And I'll give you a quick story from my litigation experience. I've probably handled a few hundred lawsuits. Vast majority shake out in a way that makes sense to me, but I think anyone that's done that amount, there's just going to be 3 or 4 that will just drive you crazy the rest of your life. And one of them is on this topic. Our client was kind of hosted computer mainframes. So there's a maintenance technician that, as you can imagine, a lot of his job was involved, using a screwdriver and pinching. That was just an important part of what he did. This was in the Twin Cities, middle of the winter. This employee, he's a very mediocre employee to start off with. They weren't really too thrilled with him. But he was at home snow blowing. Snowblower got clogged. His solution to fix that was to kind of just punch into the hole. It caught his glove and it chopped off sort of the tip of his pointer finger and his middle finger. So did it at home. Arguably was doing something that was pretty stupid. Got slightly injured, not as gruesome as some of those things can be, but couldn't really do the job anymore. The HR department at work, I thought, to any reasonable person, handled the situation pretty well, tried to get him back into his job. It just wasn't going to happen. Like I said, I think anyone that looked at that would say, yeah, they handled it in a pretty reasonable way. He ended up suing. So that company ended up paying quite a bit of money to me as the associate on the case to defend it. Even more substantial amount of money to the partner on the case to defend it. And under the Americans with Disabilities Act, which I think a lot of us wouldn't think of that as a disability, but it is under the ADA, they didn't quite dot the I's and cross the T's like they should have. And that case ended up resulting in 5 figures of legal fees for them to defend it. And a six-figure check to that guy at the end of it because they didn't quite handle it right. And I would go so far as to say that had the HR person that handled it, again, I think very reasonably to your average person on the street, that they kind of sat through a presentation like we will give on November, probably could have saved their company quite a bit of money and not been quite as uncomfortable going to work when what she did ended up costing her company, you know, several multipliers of what she gets paid in a year. So that is an area in particular where there are a lot of landmines that you would not know about whatsoever. So I think that one will be very helpful in knowing, hey, I think I'm, at the very least, even if you don't know what the landmines are, you know they're around. So I would give a plug on that one because employee termination, discipline, it's just something that can be very tricky in a way that's counterintuitive. So that's my little story there on that one. Again, that's November 19th. Jenny's, one of her colleagues will be doing that. So it'll be at the same time, 8:30. So I would encourage you to go for that. And again, respond to our survey. Let us know what we can do better and what other topics you are looking for. So thank you.